Hi everyone, this is Shauna Tarosa, RAYAC Executive Officer, and this is my desk. In this monthly video blog, we go over questions that are coming across my desk every single day so we can have much smoother real estate transactions here in York and Adams counties. And the question that I have today, it comes across my desk frequently, and it's about the timing of deposits and the deposits that are never received on the real estate transaction. Now, as most of you know, I like to make a joke on my little video blog here that I'm not an attorney and I don't play one on TV, but I thought this topic was so important that I brought in a real life attorney. And so with me today on the video blog is Peter Ruth. He is RAYAC solicitor and he's with Stock and Leader in downtown New York. So welcome, Peter.
Thank you very much for having me. Hello, everybody.
All right, so we're going to dive right into this. So Peter, I'm going to skip around a little bit about the agreement of sale, but I wanted to start off with just a basic understanding of why that initial deposit collection is so important to the seller. Now, paragraph of the PAR agreement of sale, 26G states the seller is limited to retaining those sums paid by buyer, including deposit monies as liquidated damages. So would that be a fair statement that the majority of the contracts you see come across your desk and that realtors in this area use have this box checked?
Yes, I think it's a very fair statement. They refer to this as liquidated damages, and that's just a legal term for all the parties involved are going to agree what happens in the event one of those parties breaches. So in this case, that's the buyer. Both of them agree if that buyer breaches, what's going to happen is that the seller is going to get, and you hit the nail on the head, the sums paid by buyer. So I see this a lot, and I think just so everybody knows, the alternative is if you don't have that box checked, and a buyer does breach, the buyer could theoretically be sued for what's called the loss of the bargain. So if a seller has a contract for $250,000, they're only able to then resell it after that first buyer breaches for, let's say, $200,000, then technically they've lost $50,000. They can go after that buyer for that amount if that box 26G isn't checked. So again, a lot of uncertainty there. So it does make sense in most circumstances, check that box and everybody knows what's going to go on.
But even more importantly then, we have this box checked. The buyer says they're going to make that payment and it never comes in. Seller, out of luck, right?
Yeah, that's right. The limitation is that it is funds paid by buyer. And if the buyer hasn't paid any funds, the seller is limited to retaining nothing. So in the end of the day, that seller is going to be stuck holding the bag and the buyer is unfortunately going to be able to walk away likely scot-free without having any type of legal liability.
Yeah. All right. So we're going to do a little trip down memory lane.
Wonderful.
So before, we had electronic forms in Pennsylvania, the common practice was you took that, paper contract and, stapled to it was the check for the deposit when you were presenting your offers to your client. And then obviously as electronic forms became much more of a common practice and you're emailing those forms to the listing agent, we had added into there, which is now paragraph 2 of the PAR standard agreement of sale, so that there could be additional time so you could get the deposit in because the offer was being delivered electronically. So now the paragraph 2 of the PAR agreement of sale says that the initial deposit within blank days, and that's 5 days if not specified of the execution date. So here's the big question that we get a lot and I want to get the answer from you. So if the deposit is not delivered in the time frame specified in the contract by paragraph 2, is the buyer in breach?
That's a very good question. I think that what the buyer has done is potentially expose themselves to breach by failing to complete an obligation that they had to do within a time frame that is set out in the agreement of sale. So again, that is going to be a situation where a seller could theoretically provide notice to the buyer saying, hey, buyer, you're in default by not doing this, and therefore I'm going to terminate the agreement of sale. Potentially the seller could sue the buyer for any out-of-pocket damages. If you don't have that box check, that would be included in that. So hey, let's get any of those costs. And more importantly, there's what I call specific performance. Traditionally, that's been reserved for a buyer who holds an equitable interest going after a seller who's not going to perform. 2019, the PA Superior Court actually acknowledged that sellers have a right to pursue specific performance against a buyer, but really what they're doing, it's an action for the purchase price. So you're suing them for the amount that they were otherwise supposed to pay you. So I think all of those items come into effect, but more importantly, and I think we'll talk about it a little bit from a legal perspective, Is the buyer theoretically in breach and practically in breach? I would say yes. I think the timing on that also becomes an issue and a factor as well.
So I do think that there is a common misperception out there, but just want to clear this up. If the buyer does not pay the deposit on time, the contract, though, isn't necessarily null and void.
Yeah, that's correct. This is not where a buyer just kind of says, hey, I didn't sign the contract and therefore, I'm going to walk away willy-nilly. It's null and void. That's not theoretically the case. And honestly, this happens a lot. A lot of situations where it's like a 30-day close, maybe an all-cash offer, an investment property or something like that, where you'll make an offer and something just happens. The deposit never gets collected. And I know I've been at the settlement table oftentimes and they say, oh, by the way, before we get there, we're not going to have the deposit shown because we forgot to pay it. So those parties have a valid binding agreement. Mm-hmm. They move to closing and they consummate closing. And that is just a traditional path that's taken forward. What really happens, though, I think if you're not collecting a deposit as a seller or as the listing agent, you're exposing your really the seller and the buyer, but you're not going to have an easy avenue of getting any money if the buyer defaults, right? Mm-hmm. And more importantly, you're flipping it over to the seller to kind of be in charge of, is that a default and how do we take care of that? So some things to keep in mind there. Again, making sure you're staying on top and getting that deposit. We talked about the 5 days. You can modify that. You can ask for a wire just so that they're immediately there. But there are some ways that you can kind of tap dance around that issue.
All right. So I think one of the things that we saw is that a lot of times deposits weren't coming in time because there was buyer's remorse. Mm-hmm. They said, oh, I have to get it in 5 days. I signed the seller signed my offer, but now I decided I no longer want to buy the property. So I'm just not going to send in the deposit and then I'm out of my contract. And then because I found another property I like even more and I want to put an offer in on there. So what do you say to those buyer's agents who have buyers who do not pay the deposit? Can they legally go into another contract? Or are they still in a contract with the existing offer that they first put in?
Yeah, I would be very careful. Remember, the buyer doesn't have a right to terminate as they would with like an inspection contingency that says, I don't want to take the property because of this inspection. It's not, I haven't paid my deposit, so therefore I'm going to terminate and I have a right to do that. Right. So I think if a buyer agent is not advising their client, hey, we need to address this issue before we move on to go find that other property, you're now potentially exposing that client, to having to pay 2 commissions. You're going to potentially be under an agreement there. Also to be having to pay 2 purchase prices, right? At the same time. And at the end of the day, for the agent, have you now knowingly exposed your client to that without advising them accordingly? And that gets into ethical issues and all sorts of other duties that you really want to stay away from. So if you're in that situation as a buyer's agent, I think it's, look, I understand you don't like this property, but we need to see this through, whether it's termination, whether it's a change of heart on your part, before we just run off and go sign that next contract.
Okay. So then I guess the opposite question is, does the seller have the right to terminate the agreement of sale because the buyer failed to pay the deposit in the time noted on the contract?
Great question. As with all kind of legal questions, I think you might get a differing opinion depending on which attorney you ask. My opinion personally, and this comes from Section 5 of the Agreement of Sale, and that section specifically says that all timelines herein are of the essence. And I always talk about this at new member orientation anytime I'm out in front of anybody. What does that mean? That means if I say the deposit's in 5 days and you give it to me on day 5.5, you are out of time. And what that also says is that the party who does not complete within that timeline is in breach of the contract, essentially. So my perspective is, as an aggressive seller, yes, that buyer is in breach of the contract. If it's day 6, I don't have a deposit, I can forward notice just like I would otherwise. Your failure to get a mortgage commitment by the deadline, right? Same scenario, in my opinion, would apply in this case. Although I do know you have to be a little sensitive, because if a buyer knows what they're doing, they might say, hey, I have a little bit of time here, and more importantly, I may try to pursue that, the legal word we all hate, the Liz pendants, right? To try to say you're not going to be able to sell this property. So I think, consult with legal counsel right away. But from a true legal perspective, I think the contract affords that. The other way, the belt and suspenders approach that I think, put that in the contract. If buyer has not paid deposit by the timeline set forth in that paragraph, that is a buyer default, and seller will be able to terminate the contract. Okay. Clears up all doubt.
Good idea. All right, so we know how important it is we get these deposits in on time, especially with that being checked. So what can listing agents do to protect their seller's interest and make sure the deposit is received?
Wired funds, I think, is one of the easiest ones. I know if there were many brokers, actually during COVID when we were doing settlements, we weren't even giving the brokers checks. We were wiring funds. They were wiring us deposits. Wires are immediately available funds, and it goes into the account overnight. So your electronic example for all the forms, this is just a graduation to the electronic form of that payment. If that's not the case, I think really insisting on at the time the contract is signed, making sure you're getting that, or within a reasonable time period, and understand the expectation. If someone is actually stroking a check and going to hand that handwritten check to you, they might need a little bit more time. So I think really in a seller's market, what would benefit them is by adding the language we just talked about, because that way it puts the buyer's feet to the fire. If they don't hit that deadline, I have a clear and articulable right to terminate the contract and move forward. But otherwise, it's just staying on top of that buyer's agent and the buyer, and really try to gauge. I mean, if you're getting some feedback on getting a deposit in, how hard is this going to be moving forward in a contract? Are they going to apply for the mortgage on time? Are they going to do the inspections on time? Are you going to be going back and forth throughout this whole process? So keep that in mind. But again, just doing everything you can to try to keep that buyer and get that deposit, keep that buyer's agent in communication with you.
Great. I'm going to change the subject just a little bit.
All right.
So paragraph 2C in the Pennsylvania Agreement of Sale states that deposits, regardless of the form of payment, will be paid in U.S. dollars to broker for seller unless otherwise stated here. So we are seeing a rise in the number of brokerages who have made the business decision that they are not going to hold deposits. And in some of those cases, the broker for the seller may not hold the deposit, and the broker for the buyer also may not hold deposits. And they might be using an outside entity to do that. And, to be clear, RAYAC does not make recommending any deposit method, one or the other, not making any recommendations over what you should do or shouldn't do. But what should the buyer's agent and the listing agent be aware of if an outside entity outside the broker is holding that deposit? Is there anything they need to be aware of?
Yeah, great question and great disclaimer. I'll underline that disclaimer. We're not recommending any process, but this is an avenue to help with that situation. So as we all know, there are some default provisions in the regular contract, and I use default kind of in two ways, but what happens in the event of default, the default situation is that the broker, and it specifically says broker in the agreement of sale, as you alluded to, it doesn't say escrow agent or person holding escrow. It says the broker can only release that escrow deposit in one of really 4 ways. And if none of those 4 ways comes about, then that broker is going to be holding that deposit potentially indefinitely. So that kind of underscores, I think, the best advice to give. If you're going to have somebody else hold it, that entity, that escrow agent, that law firm, that title company, they're not going to be bound by the contract unless you do what one good thing is that you make them bound by that. So what you can do is add an additional term that says whomever holds the escrow shall hold it in accordance with the terms of this contract. Now that's all well and good. I think on the fly, if you really need to move quickly, the best thing you can do, if anybody outside of that is going to hold escrow, you have to have an escrow agreement. Okay. And you might want to mimic the terms that are currently in the agreement of sale, but you need to have an escrow agreement that's signed by the escrow agent and really should be signed by the buyer and the seller and potentially the settlement company who knows all of that information and knows what's going on. But definitely by the seller, the buyer, and the escrow agent, because that will set forth when can I disperse this? When do I have to hold on to it? Am I going to be responsible for costs and expenses if it has to get paid into court? Have an agreement that sets all of that forward at the outset. So really, I mean, just to backtrack, by failing to accept that deposit, right, it's almost creating more of an issue now for your clients who are going to have to go through this additional process for you. So I think it's going to be a risk factor analysis. Is it worth pushing that to kind of, an unknown territory? What are the buyer and seller going to do in the event of an escrow dispute? Or should we be the one holding the deposit in light of all the issues that could come about? So have that agreement, have it in writing. Nobody's in confusion at that point.
Wonderful. Well, that was really great advice. We want to thank Peter for being here today and being part of our video blog series. And we finally had a real life attorney instead of one who was trying to play one on TV. But thank you all for tuning in today. If there's ever any other issues or topics you would like me to address, please feel free to reach out to me because my doors and ears are always open to you. Thanks so much and have a wonderful day.